National Security of the Third, Right Honorable the Prime Minister, Honorable President of the Senate, Honorable Speaker of the National Assembly, Honorable Deputy Prime Minister, and Honorable Ministers, the Little Chief Justice, President of the Court of Appeal, Honorable Judges of the High Court, Honorable Attorney General, Their Excellencies, Heads of Diplomatic Missions, Director of Public Prosecutions, Registrar of the High Court of Appeal, Chief Magistrates, and Judicial Officers of subordinate courts, Judicial Commissioners, President of the Labor Court, Deputies and Assistant Registrars, Judges, Clerks and Mediators, President of the Law Society, Chiefs Counsel, members of the Bar and Sidebar, Clerk of the National Assembly, distinguished guests, ladies and gentlemen, good morning. We assembled this morning to mark the commencement of the judicial year and pick stock of what we did in the past year. In the tradition of the judiciary, we start by paying our respects to those who are departed. They are the following: retired Judge of the Court of Appeal, Leonardo Phahameng, who passed on the 20th of November 2025. Judge of the Court of Appeal, Moses Bungo Chinengo, who passed on the 19th of September 2025. Retired Judge of the High Court, Winston Churchill Makanzi Mama Tutu, who passed on 28th May 2025. Retired Chief Magistrate Napo Mohali, who departed on the 27th of October 2025. Chiefs Counsel High Edward Pofolo, who departed on the 20th of August 2025. Advocate Mafefuan Mushasha, who passed on the 20th of March 2025. Advocate Pulo, who passed on the 2nd of August 2025. Advocate Sieng Letele, who departed on the 22nd of October 2025. Advocate Maza Uzizwa Tsekwisa Project, who passed on the 18th of November 2025. Advocate Tabomola, who departed on the 5th of January 2026. Attorney Mabuzwakwena Tabani, who passed on the 23rd of July 2025. May we all stand and observe a minute silence in that. Thank you. The story of backlog of cases is a never-ending one. It speaks to the reality that increasing access to courts means more and not less cases. As long as society fails to put in place alternative dispute resolution institutions and make courts its first preference to resolve disputes, backlogs are here to stay. The only way to cope with this labor of Sisyphus is by increasing the number of judicial officers. In an endeavor to have more span of oxen to plow the field of justice, the Judicial Service Commission exercises its power under Section 120, Subsection 5 of the Constitution, and advised His Majesty the King to appoint the following ladies and gentlemen, as acting judges, Advocate Sekake Malibanye King's Council, Advocate Zebam Putswani, Senior Resident Magistrate Mana Pomutebel, Resident Magistrate Pari Sarantara, and Advocate Swana Isawa. They were appointed on the 1st of September 2025 and had to hit the ground running. 18 judges, Malibanye and Rantara, served in the Southern Division of the High Court, which is located in the town of Malize. This division officially opens for judicial business today and commences hearing of cases on the 16th this month. The division will be inaugurated by the Right Honorable the Prime Minister on a date to be announced. The territorial jurisdiction of this division covers the districts of Kachasnet, Kiti, Mohalizut, and parts of Mafikeyi. The parts of the district of Mafikeyi that fall under this territorial jurisdiction will be identified in consultation with the Minister of Justice and the principal chiefs of Mafikeyi, Matehile, Haramabanta, Kubake, and Hibani. 18 justices, Motegele and the Sawana, serve in the Northern Division. This increases the number of judges in that division from 2 to 4. I once again thank all these judges for agreeing to serve. I call upon magistrates and lawyers who have unquestionable integrity and demonstrable work ethic to take up acting appointments and to come forward, submit their names to the Law Society, which will forward it to the Secretary of the Judicial Commission, so that as and when a need arises for lawyers to act, we should know those who have raised their hands. Acting appointments are the ideal way to recruit, because candidates get an opportunity to learn the ropes and get a taste of judicial office before making a firm commitment to serve on a long-term basis. But for the system to attract experienced and suitably qualified candidates, there must be an improvement in the package for judges. This is the only way to entice lawyers who are experienced and magistrates who have demonstrated work ethic to be appointed to the bench. Senior and experienced lawyers in private practice shy away from the bench because they earn more money in private practice than academia. Judicial independence and accountability are non-negotiable. Judicial officers must be free to decide matters without interference from political actors, economic interests, or popular pressure. They should not be beholden to public or private interests. The flip side of judicial independence is accountability to litigants by delivering rulings and judgments on time. Judges and magistrates account only through their judgments. Judgments which are clear, reasoned, timely, and anchored in law. Delayed judgments weaken public confidence in the judicial system and bring the judiciary into disrepute. Disciplinary measures are therefore appropriate and necessary to ensure and enforce judicial accountability. Ladies and gentlemen, another issue that leads to loss of public confidence in our courts is corruption and unethical conduct. Whether proven or perceived, allegations of corruption and unethical conduct corrupt trust and diminish the moral authority of the judiciary. Let me be clear. Corruption is not only a crime, it is a betrayal of the judicial oath and subversion of justice. As the head of the judiciary, I will not shield wrongdoing. Mechanisms for accountability and discipline exist in the Constitution and codes of ethics and will be applied without fear of failure. Integrity is not optional. It is the cornerstone for a fair, clean, and transparent judiciary that God commanded Moses to establish in Deuteronomy chapter 16, verses 8 to 20, where he said, "Appoint judges and officials for each of your tribes in every town the Lord your God is giving you, and they shall judge the people with righteous judgment. Do not deny justice or show partiality. Do not accept a bribe, for a bribe blinds the eyes of the wise and twists the ways of the righteous. Pursue justice and only justice, so that you may live and possess the land the Lord your God is giving you." Having said this, I hasten to caution against unsubstantiated attacks on judicial officers, particularly attacks and gossips aimed at influencing outcomes or undermining decisions. Unsubstantiated and unwarranted attacks and peddling of rumors of corruption undermine confidence in the judiciary. Our justice system is faced with many challenges. They include congested court halls, delays, procedural inefficiencies, whose combination denies timely resolution of disputes. All these have real human consequences. Victims of crime wait for long foreclosure, and accused persons remain in prison for a long time awaiting their trials. Business collapse and witnesses die. In response, the judiciary has embarked on targeted reforms, including introduction of new court rules aimed at streamlining procedures, keeping unnecessary interlocutory applications, and promoting efficiency. These rules are not cosmetic. They are intended to change the legal culture, promote discipline among judicial officers and legal practitioners by introducing judicial case management, in which judicial officers seize the initiative. In this past judicial year, the following rules were made. The Judicial Commissioner's rules, which were gazetted as legal notice number 105 of 2025. The Criminal Procedure and Evidence rules, which will be gazetted before the end of this month, unless the unimaginable happens to the Parliamentary Council. The Judicial Commissioner's rules close a gap that has existed for long in the procedures of that court since its establishment in 1954. This is a roving court that hears appeals from central courts in cases litigated in terms of customary law, codified as the laws of Lekhotla. The practice is to take judicial notice of these rules of customary law without a need to prove them. However, parties are at liberty to bring expert witnesses to give evidence on the existence of the rules of customary law, if they so wish. The Judicial Commissioner's court rules bring clarity and certainty in the procedure. This is important and useful to the class of people who litigate in the central and local courts. The majority of litigants in this class are underprivileged and cannot afford the services of lawyers. They are illiterate or semi-illiterate in regard to court processes, but still have basic knowledge of customary law, which forms part of our city culture. What remains is to make these rules accessible by translating them into Sesotho. This is a project that the Judicial Commissioners will see to its completion in the course of this judicial year. The criminal procedure and evidence rules fill in a gap that has existed since the enactment of the Criminal Procedure and Evidence Act of 1981, the CPN. The CPN is a substantive law of matters of procedure and evidence. It does not prescribe rules. As a result, it was left to courts of law to develop and fashion the procedure through judgments. The CPN is a prototype of apartheid South Africa's Criminal Procedure Acts of 1955 and 1977. Professor Lekhotla says that during the ages of these acts, criminal procedure was subject to the sovereignty of Parliament and the whims of the executive, resulting in the oppressive and authoritarian criminal justice system of apartheid South Africa. In other words, there was no constitution to constrain the power of Parliament in making laws and to discipline the exercise of coercive powers by the law enforcement agencies. Another gap that these rules will close is that of harmonizing procedures with the Constitution and the imperatives of constitutionalism. As a constitutional democracy, Lesotho is anchored in the rule of law. Simply put, ours is a government of laws and not men and women. Power must be sourced in laws and exercised consistently with the Constitution. Laws must be promulgated in advance, written in clear language, and be accessible to the people. This requires that those who occupy public office or enforce laws should explain their act by reference to the laws. There should be transparency in court processes. Vulnerable witnesses should be protected, and victims of crime must not only be seen, but must also be heard. The sum total of this is that investigation of crime, searches and arrests of suspects must be done strictly in accordance with the laws and procedures that protect the rights and freedoms enshrined in our Bill of Rights. I call upon all agencies that form part of the chain of criminal justice to embrace these rules in good faith. Their successful interpretation depends not only the courts, but cooperation across the justice sector. These rules are a legal instrument put at the disposal of courts and law enforcement agencies. They codify progressive principles developed by the courts down the ages and are blended with best practice gleaned from international rules of practice. Their object is to turn around our criminal justice system from an authoritarian era to a human rights centered one. The votes for operating costs and acquisition of non-financial assets for the judiciary have steadily increased from 14 million in financial year 2024-25 to 62 million in financial year 25-26. This constitutes an increase of 114%. Despite this increase, for which we are grateful, the budget is still low for an arm of state that is the custodian of the rule of law and justice, which delivers justice to all citizens, including the other two arms of state, that is the executive and parliament. And an investment in justice is an anchor for social, political, and economic justice. It is an investment that yields peace dividends. We thank Parliament and the Executive, which holds the purse, for having found it necessary to make this modest increase of the budget. I urge these two arms of state to seriously consider our proposal in the draft 11th Amendment to the Constitution, wherein it is proposed a formula which will sustain budgeting for the judiciary. The judiciary benefited from the efforts of the Ministry of Public Works and the Sutu's development partners to refurbish courts. The following was done. The children's courts in the districts of Lekhotla and Mafeking were refurbished. This increases the number of fully functional child-friendly courts to 7. Refurbishment of the following courts has been completed. Tabatseka Magistrates Court in the district of Tabatseka. Mapulani Local Court in the district of Lekhotla. Pulo Local Court in the district of Tabatseka. Matala Local Court in the district of Maseru. Lekhotla Local Court in the district of Beride. Sifiki Local Court in the district of Berea. Itse Local Court in the district of Beride. Mount Morosi Local Court in the district of Tuti. The following courts are going refurbishment. The High Court, the main division, especially the Commercial Court. Maputo Local Court in the district of Beride. Mamalana Local Court in the district in Makiriri. Ikwene Local Court in Mohalizu. Makwara Local Court in Mohalizu. Maputo Local Court in Mohalizu. Ramukwasi Local Court in Mafeking. Kweme Local Court in the district of Maseru. And Mamate Local Court in Berea. The efficiency of courts in delivering justice is measured by effectiveness in handling cases with reasonable speed without sacrificing fairness and quality in the process. Cases that are managed well take relatively shorter time to dispose, and this is an indicator of good case management. The statistics that I'm about to read do not answer questions asked by typical litigants, which are the following questions. 1, how long will my case take? 2, when will my first hearing be? 3, how often will I be summoned? 4, do I have emotional and physical stamina to take the toll of cases that take ends to complete? Lastly, can I afford a lawyer's fees for every day that the case is postponed? A total of 12 cases from both sections. There were 106 cases that were enrolled in the Court of Appeal. 98 were completed, and a total of 12 of them were postponed because of incomplete records at the request of the parties. None of the reasons for postponement included absence of written judgments by judges of the High Court. This shows that judgments are being delivered in compliance with the 90-day rule. In the High Court, in the main division, 1,474 cases were registered, 563 were allocated, 1,090 were completed. In the Labor Court, 46 were registered, 20 were allocated, and 5 were disposed. In the Land Court, 47 were registered, 31 were allocated, and 33 were completed. In the Commercial Court, 612 cases were registered last year. 112 were allocated. 718 were completed. And this 718 includes cases which were dragged from the year 2024. In the Northern Division, 84 cases were allocated and 293 were completed. Now this 293 also includes cases which were allocated previously in the year of in the year 2024. In comparison with the previous year statistics, there is a notable increase in the number of cases completed. Contributing factors include effective case management. Another commendable achievement is the disposal of criminal trials in the High Court and the harsh sentences which are imposed. These sentences send the fear of God in the hearts of criminals. They also soothe the broken hearts of victims. Be that as it may, sentences do not repair the damage caused by crime. Time is long overdue for Lesotho to pass laws that compensate victims of crime in accordance with the 1989 UN Declaration of the Basic Principles of Justice for Victims of Crime and Abuse of Power. There is anecdotal evidence that these harsh sentences are bringing back public confidence in the criminal justice system. Turning to the constitutional cases, 31 were enrolled this year or registered, 10 were had, and 6 were completed. Court annex mediation, 217 cases were referred for mediation, 60 were settled, and 101 of them failed mediation. In the Northern Division, 33 referrals were made, 8 were settled, and 14 failed. Performance of the court annex mediation remains unsatisfactory because of litigants' failure to reach agreements. This platform provides an opportunity for litigants to explore settlement before they appear before a court. But so far the process does not maximally achieve its purpose because of legal advice by lawyers for parties not to agree to anything without their approval. The main culprits are lawyers that represent the organs of the state. This conveys a bad message that the Crown is resisting mediation efforts and any settlements in cases where the state is sued by its own citizens. In the Labour Court, 490 cases were registered, 463 were allocated, and 169 were disposed of. The number of completed cases in the Labour Court has declined by 22% from the previous year in which 217 cases were completed. In the magistrates in the Central Region, 4,669 cases were registered, 4,592 were allocated, 3,193 were disposed. In the Southern Region, 1,322 were registered, 1,580 were allocated, 451 were disposed of. In the Northern Region, 3,539 cases were registered, 2,285 were allocated, 1,275 were disposed of. Performance of case disposal in the Magistrates Court has declined by 51% compared to the figures of the last judicial year. This is a matter of great concern because those are the courts which are accessed by the majority of citizens in this country. The Law Society, its members who practice in that court, know the good reasons and the bad ones why these cases are not handled timely. And I rely on the Law Society to bring to my attention these factors, be they human or infrastructure. I'll do the necessary to hold the Chief Magistrates accountable in this regard. In the Judicial Commissioner's Court, 126 cases were registered, 170 were allocated because there were those which were brought forward from 2024, and 154 were disposed of. Delays in the justice system is a hydra-headed monster that has the ability to multiply itself when it is cut into pieces. Experience teaches that delays elude rigorous enforcement of rules of court, practice directions, and resource-intensive interventions. The scientific method of managing delays is to adopt a whole-of-sector approach to find which of the justice sector institutions contributes most to the delays and the reasons thereof. This we have to do in order to adopt strategies to solving the causes of these delays. This is an exercise that is being done by the Justice Sector Forum that was launched by the Right Honorable Prime Minister in 2024. In the past year, the forum did the following. It established district sector coordination forums, which consist of all criminal justice sector institutions in 7 districts.